said that there actually is a difference because the juror is more used to integrate schools, while de facto is still not really based on race, more based on in-school cliques.
Okay, all right. So I see. So when you say de facto segregation is based on in-school cliques, what you're talking about is kind of segregation that occurs within the school, right? So you're talking about, you know, folks like to hang out with folks who look like them, right? This kind of thing, right? And maybe there are social pressures, cultural reasons why that's the case. What we're talking about when we say de facto segregation, actually, is we're actually talking about segregation in between schools, right? So Mr. Dunbar alluded to this on Tuesday, but there are many schools in this country, many school districts where there remain schools that are, you know, 99% African American in the same district where there are schools that are majority white, right? And so, you know, the question. So I think what you're saying is absolutely right, right? It's an important point, and it may even help explain de facto segregation between schools. But it's slightly different from what we're talking about here. Does that make sense?
Neighborhood, right?
It could be neighborhoods. Yeah, Robert, what's up?
I said the difference between de jure and de facto is the law. Just because something is just outside of the law doesn't mean there should be a law for it. Integration of schools is an option. Brown v. Board, there was not this option.
Okay. All right. Phil, you want to say a little bit more about what you mean in Brown v. Board there was not this option?
Like before Brown v. Board, like there wasn't this option of black kids going into white schools, whether it was in the suburbs or just across the street.
Okay.
But like that law shouldn't exist. But like it's the parents' decision or the child's decision to move schools.
Okay.
They feel they have the opportunity to do better in one school versus the other.
Okay. All right, good. So you're saying parents are playing a role in kind of perpetuating de facto segregation, other folks, right? Okay, that's good, right? DT, were you about to jump in here? Oh no, it's not if I want, it's if you want. I mean,
de jure, I think segregation is important because it makes it illegal for people to try to make schools segregated.
Okay.
Something in the book about a school, like intentionally.
Can you speak up a little bit?
There's a case in the book where a school like intentionally made schools segregated, kept on making them segregated. So because of de jure, it's illegal.
Right. Okay, good. So it takes some power away from school administrators, right?
It doesn't end segregation though, but it helps it a lot.
Good. Okay, right. So it's a step in the right direction. So maybe, you know, it's an important distinction, one we need to address, right? But that's not to say that de jure isn't important, right? It's just to say de facto is important to think about too, right? Do folks have other statements? Folks agree, disagree? We're going to be talking a lot more about this over the next few classes. But I wanted to get us started kind of on this difference. And I also, again, wanted us to talk about the present because what we're going to move into now is the history, right? So here's today's agenda. We just had our opening discussion on segregation today, right? Which, again, you know, we're referring to de facto segregation. What we're going to do now over the rest of the class is we're going to jump into a lecture about what happened after Brown. Okay, we'll do a quick recap of Brown at the beginning just to jog the memory. We'll talk about what happened after Brown. After that, we'll jump into a group work activity where you all get a chance to apply equal protection doctrine, right? Which is, again, the Equal Protection Clause was kind of the basis for the Brown decision, right? And for the decisions that you all read for class today, right? Cooper v. Aaron, Griffin, right? These cases are all kind of premised on the Equal Protection Clause. We're going to get into the kind of nuts and bolts of the rules of that, and then we're going to play a game together called Scrutinize This, okay? And that'll be another chance for us to, as a class, apply that doctrine, okay? Any questions on today's agenda? Good. Okay, so let's start with just a quick recap on Brown. Really just very briefly, again, Mr. Dunbar went over this on Tuesday. But, you know, we know that prior to Brown, right, the norm in the South, at least, right, the norm was segregated schools, right? And we can see here, there's an example of a schoolhouse in Memphis just a few years before Brown, right? It's overcrowded. It's entirely African-American. This was the norm prior to Brown. And then, right, these noble, brilliant attorneys, right, the NAACP Legal Defense Fund, create this plan, right, that they begin implementing throughout the 40s and early 50s. This is the build-up to Brown. Brown, right, was talking about the integration of elementary and high schools, right? That was the holy grail of integration for these folks, right? Prior to that, right, they, you know, as Mr. Dunbar mentioned on Tuesday, they were targeting graduate schools, law schools, right? They were kind of trying to pinch the court towards this decision where they would ultimately have to say, yes, primary, secondary schools must be integrated, right? And so here we see the group that really created that plan, right? The great Thurgood Marshall here, right? We see Robert Carter, Spotswood Robinson, right? All three of these folks went on to become federal judges. Brilliant, brilliant attorneys, all members of the Brown team, as was this woman, one of my idols, Constance Baker Motley, who I wanted to throw up here. She also became a federal judge later in life. I didn't want to just throw her up here because she's important and inspirational, but also because she's from right here in New Haven. She actually grew up just a few blocks from here over on Dwight Street, went to church over at St. Luke's on Whaley Avenue, and she was one of the only women, maybe the only woman, on the team that argued and won Brown. New Haven native, graduate of Hill House High School. Great. So, that's the build-up to Brown. We all know what happened in Brown, right? Brown was a great victory for integration, right? It was a great victory, 9-0, a unanimous decision, right? It was great news for Linda Brown and her mother, depicted here on the front steps of the Spring Courthouse. It was a great day, not just for the Browns, but for school children across the South, for their parents across the South. It was a great day for liberty, and a great day for justice, and a great day for the United States of America, right? But what happened next? And that's the question that we're going to focus on today, right? What happened after Brown, right? And so immediately after Brown, kind of the place that I want us to start, right? This next story, which by the way doesn't have the kind of fairy tale ending that Brown had, right? As you might guess from the cartoon that we started class with, right? This story is a little bit more complicated, a little bit more rough, and it begins with a case called Brown 2. Right, cleverly titled Brown 2, right, which involved the same parties as Brown 1, Linda Brown, the school district of Topeka, Kansas, and Brown 2 was addressing a different question, right? So I've kind of tried to divide this up into a kind of a clear way so that we can understand the difference between Brown 1 and Brown 2. In Brown 1, right, the Supreme Court was dealing with the question of whether or not school segregation was constitutional, right? And how did they answer that question? It wasn't. Right, exactly, right? Very easy, right? The Supreme Court held in Brown, right? Separate educational facilities are inherently unequal, right? And unconstitutional. But the court didn't get to this question of how school districts should go about integrating, how they should go about the process of desegregation itself. Okay? Do they do it quickly? Do they do it through busing? Do they, all these questions, right? Because you're talking about, a system that had been in place for years, right? The question is, how do we go about dismantling that system that we have now said is unconstitutional? And that was the question that the court started to answer, or we could say didn't really answer at all, in Brown 2. And the answer that they gave was that schools that have been ordered to desegregate must do so with all deliberate speed. With all deliberate speed. What does that mean? With all deliberate speed. Henry.
I think it means whenever they choose, what speed they choose to do it.
Good, right? So I think that's basically the right answer, right? Deliberate here. So we all know what speed means, right? Deliberate kind of undermines speed, right? When you do something deliberately, you're doing it slowly, you're doing it carefully, you're not rushing into it, right? You're not moving through it recklessly or hastily, right? That's basically what with all deliberate speed means. And it's a phrase that many people think has caused a lot of the problems that happened after Brown with the school integration process. It's a phrase that has been adopted in recent films, in recent books. It's an important phrase, and it doesn't come from Brown, it comes from Brown 2, right? And it's about the process of how do we go about integrating. Okay, that's where our story about what happens after Brown begins, right? And when you say things like with all deliberate speed, Henry alluded to, well, it kind of means go at whatever pace you want to go at, right? It kind of gives a lot of deference to the folks who are actually going to go through the integration process, right? Those folks had this particular view of integration, right? This is a cartoon that was released 1954. This was released the week of the Brown decision, okay? This is the same week that Brown v. Board 1 was decided, right? And we have this comic, right, by John Kennedy. No, not that John Kennedy, just a local cartoonist in Little Rock, Arkansas, who has this image, right, where we have a racehorse coming into this field. The racehorse is labeled forced progress, and there's a guy dressed up like a judge, but he's wearing a graduation hat, which is kind of a non sequitur, but we'll pretend that John Kennedy didn't mess up on that. And then he's saying, you're not going fast enough, try this one, and he's telling this guy who, the South, who's got this horse, what they've labeled gradualism. All right, there's a lot of stuff going on in here. You don't need to follow the cartoon perfectly. The point is, right, a lot of folks in the South felt like they were forced to adopt integration too quickly, right? And a lot of them reacted defiantly to that. And so here we have George Wallace, who Mr. Dunbar alluded to on Tuesday. George Wallace, who, fresh off the heels of his election in 1962, was being inaugurated as the governor of Alabama in 1963, and he gives this famous speech, this famous moment, his inaugural address, where he says, in the name of the greatest people that have ever trod this earth, he's not talking about Alabamans, draw the line in the dust and toss the gauntlet before the feet of tyranny, and I say, segregation now, segregation tomorrow, segregation forever. Okay? This was the face of Southern white resistance. This is the face of what we're going to call, in this class, massive resistance, which was the reaction of much of the South, many white Southerners, to these kind of school desegregation orders. George Wallace is a good representative of what that looked like. A state official who really did not want to move quickly through integration, right? And maybe you're asking yourself, well, how did someone like George Wallace get into office, right? I mean, there are a lot of people that would have opposed this particular view, right? And we got to think, in 1963, in the late 50s, right? This is all prior to the Voting Rights Act of 1965, right? So many African Americans at this time, although they were technically enfranchised by the 15th Amendment, as you all learned on Tuesday, right? Many of them, in practice, couldn't actually exercise their right to vote. They were kept out of state elections. And so that made it easier for folks like George Wallace or Orville Faubus, who we'll talk about in just a minute, folks like that to get elected, right? Because they were, black folks and other folks were kept out of polling places by poll taxes, right? Grandfather clauses. This is familiar to folks, right, from their history classes. Okay, good. Right, so that's George Wallace, right? That's kind of the moment, right, where our story for Cooper v. Aaron begins, right? So here's kind of the build-up to Cooper v. Aaron, right? 1954, Brown v. Board. Y'all are experts in that now, right? 1955, Little Rock, Arkansas, in response to Brown v. Board, submits its desegregation plan to the city. All right, the head of schools in Little Rock, Arkansas was a man named Virgil Blossom, who creates this plan, and he says, okay, again, all deliberate speed, we're going to move slowly. We're going to begin in 1957, even though Brown was 1954. 3 years. That's plenty of time, or so he thought. 1957, they select, by the way, Virgil Blossom is a kind of a tragic figure, not just because his name is Virgil Blossom, but because he was actually one of these folks who was forced out because he wanted to actually kind of go through with integration. And even he was a moderate. I mean, we could see, right? He wanted to take 3 years. Even wanting to take 3 years, folks in Little Rock still, that's too fast, right? And they forced him out of kind of his post as head of schools in Little Rock, Arkansas. Enough on Virgil Blossom, except to say one more time, his name was Virgil Blossom, right? I mean, okay, all right. So 1957, right? The school district selects 9 students, right? 9 exceptionally gifted students academically, but 9 students who they found to be mature, right? Kind of even-tempered, who they thought would be the perfect candidates to integrate Little Rock Central High School. These are the 9. They've come to be known as, very creatively, the Little Rock 9. They were mostly juniors and seniors. What's that part?
There's 10 kids.
That's crazy.
One of them is, there's 10 kids there?
Yeah.
One of them is a sibling. I don't remember which one. I should know this. I got Virgil Blossom. You guys got to give me some credit there, right? Okay, I messed up on the number here. Counting's not my forte, but okay, all right, there were 9 of them. That's what we need to remember. The Little Rock 9, despite whatever pictures I'm putting on the board now. All right, right, so they're selected, right, and again, they decide, 1957, that's the year, they're going to integrate Little Rock High School. So Little Rock Central High School, what happens? First day of school, they show up to Little Rock Central High School, and they're met by the State National Guard, by the Arkansas National Guard, who'd been deployed by Governor Orville Faubus, because Faubus thought, we're not going to integrate our schools. Even if I have to put armed troops on the ground to keep these high schoolers out of my school, that's what I'm going to do. And that's exactly what he did. So here we have the Little Rock 9. They're here. They're being faced down, stared down by the Arkansas National Guard, who's saying, we were told not to let you into the school. Obviously, they didn't attend school that day, right? Here's Orville Faubus, right? This is him conveniently holding up a sign that states what he thinks. And it's basically, he's against the racial integration of all schools within the Little Rock School District, right? This is the reason why he put troops on the ground. This is why he didn't want them to integrate. This is all happening September 1957. The president, Dwight Eisenhower, doesn't like this. He feels that Faubus, right, Arkansas state officials, they're disobeying the law of the land. They're disobeying the Supreme Court. The Supreme Court says you have to integrate your schools. Why aren't you doing it? President Eisenhower calls up Orville Faubus, says, why don't you come up here to Rhode Island? Eisenhower was on vacation, but he thought this was an important issue, so he'd address it before he left vacation. Newport, Rhode Island. Faubus goes up. This is one of the only pictures captured of that very, very brief meeting. And Faubus, is being told by the former commander of NATO allied forces, by the guy who basically won World War II, by this intimidating, imposing, military figure, I want you to integrate your schools. And so Orville Faubus, right, genuflects and says, okay, will do. I will integrate my schools. Except the thing is, he goes back and then he doesn't do it. This kind of upset Eisenhower a little bit. So Eisenhower, in what I'm not sure many people would really call an overreaction, sends in the army. He sends in the army. He nationalizes the state National Guards. Basically, he takes power out of the hands of Faubus, removes the troops that Governor Faubus had put on the ground, and puts in his own troops to escort these students into the school. Right? Literally, the army right? All right. Not a good moment for Governor Faubus. Governor Faubus, by the way, Orville Faubus, right? Do folks know who Charlie Mingus is? Some musicians in the room, no?
Jazz, right?
Jazz, right. Good, exactly, right? Mingus kind of immortalized Faubus in a classic song, I think from 1960, Fables of Faubus. It's worth checking out. One of many suggested, cultural, extracurricular explorations that you'll get in this class. But there's one, right? So the Army comes in, they escort the students into school. Unfortunately, not all the students got the message about where the Army was going to be meeting the night before. They had to change the location, the meeting location, at the last minute, right? Very cloak and dagger. They didn't want these crowds to get to students. This is Elizabeth Eckford, the student whose family didn't have a telephone, and so she didn't get the message about the changed location. And she's forced to brave this crowd, this hostile, violent, racist crowd on her own.
That lady looks like she's going to hit her.
That lady does look like she's going to hit her. Fortunately, no one hit her. Plenty of people did spit on her. They hurled all kinds of epithets, racial and otherwise. The thing I want you to remember here is this girl is your age, okay? She didn't ask to be a civil rights hero, right? She was selected for integration, and she's your age, okay? And here she is kind of, I think, handling this extremely difficult situation with aplomb. This lesson in constitutional law is harder than anything I think Mr. Dunbar or I have ever given you, right? And she's braving it here with grace. So, Cooper Varian, this is the case you all read, right? This is where Little Rock, after, resisting and resisting and resisting integration, is told by the Supreme Court, you have to integrate, you have to, right? The Supreme Court here, 1958, has an opportunity to go back on what it said in Brown, right? It stared off the edge of the cliff, it's seen what it's waiting for it, right? What's waiting for integration, right? Past Brown v. Board, and it's ugly, right? It's this, right? It's this, right? The Supreme Court has an opportunity in 1958 to say, we didn't want all that, and we're going to go back on it, but they don't. They don't. They instead, where are we going here? There we go, right? They instead say, extreme public hostility to integration, that's not a good enough reason, and they say this, right? They say, the basic decision in Brown was unanimously reached by this court, and that decision is now unanimously reaffirmed, right? They're sticking to their guns, right? They're saying Brown is the law, and we're going to keep holding by it, right? Part of the reason they can do this is because they know they've got the support of the president who's willing to send in troops if he needs to, right? But that's where they are now, right? And actually, this is a very nice story, right? Here we have Elizabeth Eckford, right? Here, Elizabeth Eckford, talking to one of these, angry, in fact, actually, Here, right? This woman here, that's Hazel Masry, and look at this, right? They're friends, right? This is a nice story, right? Right? Cooper v. Aaron, right? Brown v. Board wasn't necessarily happily ever after because we had these problems in Little Rock and other places, right? But now, right? Surely now, right? Happily ever after, right?
No.
Shelby's picking up. See, we have a theme going here. Remember I alluded it's not a fairy tale ending, right? This is what we in the teaching business call a theme, and Shelby is all over it, right? So here we go, right? Griffin v. School Board of Prince Edward County, right? This was the next case. You all also read this. What happened in Griffin?
They closed public schools, right?
Right. Who closed public schools? Exactly, the county, right? Prince Edward County in Virginia, right? And what did the court decide in this case? It was... Right, it violated the Equal Protection Clause, right? So Prince Edward County, their reaction, right, they were so opposed to integration, they said, we're just going to close the schools, right? Many places in the South were so opposed to integration that rather than integrate their swimming pools, they filled the swimming pools with cement. Nobody swims, right? We're going to cut off our nose to spite our face, right? And the problem with this was obviously, not for many white students, they were able to attend private schools. These private schools were exclusive. There was no private school for African Americans. This is why the court kind of held this is unconstitutional. You can't do this. It violates the Protection Clause. It violates what we wanted to do in Brown. The federal government and the black community in Prince Edward County tried to put together what they called free schools. Here's a picture of one of them. But nevertheless, that wasn't enough. They said the Supreme Court says this is unconstitutional. We need to move forward, right? So shortly after that, we lived happily ever after. Well, no, not quite, right? Because there are still some other places where segregation exists, right? Hernandez v. Texas decided the same month that Brown was, eliminates racially based jury exclusions, right? A very important case, right? Loving versus Virginia, we talked about on Monday, right? That's striking down anti-miscegenation laws, holding those unconstitutional, right? So now we're starting to get rid of segregation in other parts of society, right? Outside of schools, right? And surely, after that, we live happily ever after, right? Right, Shelby? No? No, right, no, not quite, right? Not quite happily ever after. Jim Crow, not quite dead, right? So we have here, you guys like the Jim Crow? I put a lot of time into that, I appreciate it. That was a homemade slide you all just got. Milliken v. Bradley, 1974. This is another one of these plans to integrate school districts, right? Here, the court is dealing with a busing plan, a plan to take students and bus them across districts in order to create integration, right? Why? Because neighborhoods were still segregated, right? And the idea was we want to integrate our schools, some folks are going to have to do some traveling, someone's going to have to get on a bus. Supreme Court says, not so much. Supreme Court doesn't think this is okay. All right? So we're starting to see kind of rolling back, right? This is the problems that are associated with all deliberate speed, right? These are the problems that are associated with resistance to these busing. And this resistance is now, when you're talking about busing, it's expanding. It's not just in the South, right? It's happening in places like Boston, Detroit, okay? There's a strong resistance to busing, to these means of actually achieving integrated schools. Missouri v. Jenkins, fairly recently, right? One of the few cases in this unit that we'll read that actually happened after you all were born, right? Missouri v. Jenkins, right? This is a district court in Kansas City, Missouri, ordered the creation of an urban. I'm tired of reading. Can someone read this for me? Terrence? Just on Missouri v. Jenkins.
The district court in Kansas City ordered the creation of an urban magnet school with highly paid teachers in order to attract white students from the suburbs to urban schools. The Supreme Court strikes down the district court's.
Right, so here's another attempt to create integration, right? We're going to create this beautiful school in the middle of the inner city, and that way we're going to attract white students from the suburbs to come into the schools. The Supreme Court says you can't do that, all right? You can't do that, all right? So we're dealing now with kind of the backlash to integration, right? The court's finally having to recognize the resistance to these, these integration plans. Why was there a change, right? Why was there this big change from Cooper v. Aaron and Griffin v. Prince Edward County School Board? A couple of reasons. One is that residential segregation increases during this period. And the reason it increases is because of something called white flight, right? Which is the exodus, the mass exodus of many middle-class white folks from urban centers to the suburbs, right? So we're getting kind of an increase in residential segregation during this period, right? That is in housing segregation where people live, right? And at the same time, the court itself has become more conservative, right? Earl Warren, the liberal Republican from California, right, who Mr. Dunbar mentioned on Tuesday, right? He was the one who really kind of made Brown what it was and many of these other decisions. He leaves in 1969. He's replaced by the much more conservative Warren Burger, Chief Justice Warren Burger. And that's another reason why the court is less willing to kind of move forward with integration in the way that the Warren court was. Great. Do folks have questions on this history? This massive resistance to Brown, the rise of de facto segregation after Brown?
Why did it stop?
Why did what stop?
Today, it's not as bad.
Not as bad. Okay, so what do you mean it's not as bad?
People aren't resisting.
Do you think that's...
as much?
Okay, all right.
Like it was totally different from back then, 20, 10 years ago.
Okay. I want you to hold that thought until next week, because you may have a different take when we read a couple of other recent cases that kind of deal with the resistance to integration. Mr. Dunbar, yeah, what's up?
So I just want to make a point. This maybe connects to a little bit what DC just said. So on Missouri v. Jenkins, it's important to remember it's not that the court said you can't have an urban magnet school and attract people. What they said is the district court lacks the power to force the school board to make it. You see what I'm saying? So this, in New Haven, your representatives and your mayor have created these magnet schools and these charter schools. That's still perfectly legal. In Missouri v. Jenkins, the school board, the city didn't want to do that, and the court tried to force them. The Supreme Court stepped in and said, no, the district courts lack that power. Okay, and so part of the reason I think there was resistance in places like Kansas City, but not here, is, I mean, it goes back to the culture, but it's also when the court forces you to do something, typically there's more resistance to that than when your elected representatives sort of set it up. Because you can't elect judges, right?
Right. That's an important point, but again, I want us to hold off because we are going to get to some plans that were implemented by school districts, by outside the judiciary, that were struck down by the court in a case called Parents Involved, which you'll get to next week. So I want to kind of hold off on that question, but I want us to kind of table the idea that resistance isn't as bad today, all right? Because maybe we don't have the same moments where we need to send in the army to integrate schools, but I think there's still strong resistance to many of kind of the things that are needed to actually make integration a reality. Okay, so we'll hold off. That's a great question, though, DT, that you're thinking exactly on the right lines. Okay, let's talk a little bit about the Equal Protection Clause just briefly. We're going to go over this in much more depth on Monday, but I want us to just touch on this now, right? So we know that the Equal Protection Clause, the text of the clause says this. Can Robert, can you read this for us?
No state shall denied to any person within its jurisdiction equal protection of law.
Right, so Mr. Dunbar touched on this language on Tuesday. I wanted to talk about how we get from this language to things like Brown, right? It seems like there's a bit of a jump, right? This is very ambiguous language, like much of the Constitution, right? How do we get from here into the actual cases themselves? How are those cases decided, right? I even had a slide for that. How about that? How do we get from here to there? Okay, all right, we'll not that clever. All right, here we go, right? So basically the way we do it is we have these three levels of scrutiny, okay? We have, Mr. Dunbar again alluded to this on Tuesday, but we have strict scrutiny, which is the kind of the test that the court is going to use when it comes across racial discrimination, all right? We have intermediate scrutiny, which is what the court is going to use when it comes across instances, laws that discriminate based on sex or gender. And then we have rational basis review, right, for everything else, right? That means discrimination based on age, disability, income, everything that's not race, and it's not gender generally, right? I mean, we're gonna hold with these rules today. Think of these as, you guys remember. You guys, I think at this point have an understanding the court applies tests to determine whether something's constitutional or not, right? So, we're in a school. What is the test that a court would use to determine whether or not a school rule has violated a student's First Amendment rights? A couple of tests, but what's one of them? Tinker. And what is the rule in Tinker?
Schools have the right to censor speech when it provides a material of substantial disruption.
Right, when the speech creates a substantial or material disruption, it may be restricted, right? So that's the same thing, that's a test, right? Is the school rule constitutional? And the answer is, well, depends, on the Tinker test, right? Same thing here, right? Is a racially discriminatory law constitutional? It might be, but it has to pass strict scrutiny. Is a law that discriminates on gender and sex constitutional? It might be, but it has to pass intermediate scrutiny, right? Same with other laws that are discriminatory and everything else, right? We're going to go over all this on Monday.